when a decision of the higher court is been given, that has to be followed by all other courts. So the mercantile law is related to the commercial activities, that is the trade and commerce of the people of the country. It says every agreement and a promise enforceable at law is a contract. Welcome you all, dear students. Myself George William A, Commerce Faculty, Department of Commerce, Vidhyaashram, Mysuru. Dear students, in the last class I had explained to you about the syllabus part regarding business laws for your 6th semester BCom. Today I am going to discuss with you regarding the first unit about this particular subject, business laws. So in session 1, we are going to take up the first unit and we'll be dealing with many of the topics. First and foremost, I would like to explain to you about the meaning and definition of law. Students, it says law refers to the principles. Law refers to the principles and the regulations which is been established. Established by whom? By the government. And it is applicable to the people, to the general people or the public, whether in the form of legislation or of custom and policies, which is being recognized and enforced by the judicial decisions. So again I repeat, law refers to the principles and the regulations established by the government and applicable to the people or to the public, whether in the form of legislation, that is an act, or a form of custom and the policies which is being recognized and it is being enforced by the judicial decision. So I think you have understood the meaning of law. Students, we can see the other set of meaning which is about law. It says law means the set of rules. What is law? It says it is a set of rules. It may be defined as, this is the definition, it may be defined as the rules of conduct which is been recognized and been enforced. So the law is been recognized first and it is been enforced by the state, that is the government, in order to control and regulate the conduct of the people and in order to protect their property also, right? And their contractual rights with a view to securing justice, peaceful living and social security. So the main important here is securing justice, peaceful living and about social security. Now students, you can see the person Salmon, he defines the law as what? Salmon defines the law as the body or principles which is been recognized and applied by the state in the administration of justice. So Salmon defines law as it is a body or it is the principles, the set of rules and regulations which is been recognized as well as which is been applied. First it has to be recognized and it has to be applied, applicable on the people and by the state in order to administrate of justice. So in order to see that to get the justice for the people, the law is enforced. Now students, coming to the sources of business law, as you understood the meaning and the definition of business law, let us understand what is the source of business law. See, in olden days when the law was not enacted, they were going according to the different laws which was existing at that time. Such as it may be the Hindus were practicing the Hindu law, Muslims were practicing the Mohammedan law. So likewise, they used to follow the different laws. And in the later stage, what happened? When the both, that is the Hindu as well as the Muslim law, if it was silent, then they thought we should go into further laws where it says, where they came out with the source of business law. So the important source of business law are, first one is legislation, second is the custom, third is the case law, fourth is natural law, and fifth one is the English law. So there are 5 important sources of business law. First one is the legislation, second is custom, third is case law, fourth is natural law, and fifth one is English law. Now let us understand one by one. First, legislation. What do you mean by legislation? It says it is a common source of law. Legislation is a common source of law where both the parliament and the state assemblies, this is very important, both the parliament and the state assemblies have enacted a number of legislations, and that covers the various aspects of business. So, legislation means it is a common source of law where both the parliament and the state assemblies have enacted, have brought into force number of legislations that covers various aspects of business. Now, second source of law is about custom. What is a custom? It says a substantial part of business law is a customary, notwithstanding to any advances and made in science and technology. So, a substantial part of business law is customary, where it says it is notwithstanding advances which is made in science as well as in technology. This is true. Why? Why it is true? Because both in the developed and developing countries, a custom when accepted. So, in the developed and developing countries, a custom when accepted by the courts and incorporated, registered or brought into force in judicial interpretations becomes a law. So, that is why it is important. So, in the developed and developing countries, a custom when it is accepted by the courts and incorporated in the judicial interpretations becomes a law. So, this is about the second source of law, that is custom. Now, coming to the third source of law, that is case law. See, case law is popularly called as precedent by lawyers in a judgment of superior court, which is including a point of law or the principle and which necessitates its adoption. First and foremost, you should understand, students, the meaning of precedent. What is precedent? Precedent, it says, when a decision of the higher court is been given, that has to be followed by all other courts in the matter of decision, right? So that is about precedent. So case law is popularly called as the precedent by the lawyers, and it is a judgment of the Supreme Court or the superior court, we say, right? Which is including a point of law. So what the superior court has given, the law or the decision has been made, that has to be adopted by all the other courts. All the other courts are the lower courts. That's what it says under case law. And attendance in subsequent case involving the same point of view. Now, case law is useful in as much as it helps the courts to render uniformity with regard to the interpretation of status or formulation of policies. Now, this case law is very much useful for the other courts because it will help or render uniformity in taking the decisions. That is, in regard with interpretation, taking the decisions or coming to a conclusion of status or formulating of policies. Now, we are going to see the fourth important source of business law, that is the natural law. Students, natural law, natural justice is another source of law. It says the natural justice that no man can be punished. Please listen carefully. It says the natural justice that no man can be punished twice for the same crime is guiding principle of any legislation. So here, no man can be punished twice for the same, or he cannot be punished for the same crime which he has committed twice. So here, similarly, the natural justice demands that no individual can be dubbed guilty unless the charges are proved against him or her. So it says, natural justice demands what? Natural justice demands that no individual can be dubbed. No individual or individual person can be dubbed guilty. That means he should not be convinced as a guilty unless the charges are being proved on him, right, or against him or against her. Now, English law or business laws are largely based on the English Acts, which is applicable in England. And we have Sale of Goods Act, that is, for example, has been taken directly from the English Sale of Goods Act. Similarly, the Companies Act also responds with the English Company Act. So these are the 4 important sources of business law. So students, you might have understood about the source of business law. So there is one more law, that is the 5th law, that is English law. What is English law? Business law are largely based on English Acts applicable in England. So whatever the business laws are there in India, these are largely based. The foundation is on English Acts applicable in England. Our Sale of Goods Act, for example, has been also been directly taken from this English Sale of Goods Act. From where it has been taken? From the English Sale of Goods Act. Similarly, a Companies Act corresponds with the English Companies Act. So it says even our Companies Act corresponds with the English Companies Act. So these are the 5 important sources of business law. So I'll just tell you the headings. First one is legislation, second is custom, third we have case law, 4th is natural law, and 5th one is English law. Now students, let us go to the next topic, that is regarding the meaning and definition of business law. Now what is a business law? It says business law is also called as commercial or mercantile law. Business law is also called as commercial law or mercantile law, and that is the branch of legal system. So this business law is that branch of the legal system or the civil laws which will regulate the business activities. So whatever the business activities takes place in a country, that will be bound by this business law. Now business law is that portion of legal system which guarantees an orderly conduct of business affairs and settlement of legitimate disputes in the just manner. Now why this business law is important? It says business law is that portion of a legal system. That is, business law is what? It is a legal system which will guarantee an orderly conduct of the business. It will see that the business is going in a proper way, right? That is, legally it is being done. And the affairs and the settlement of legitimate disputes in just manner. It means not only conducting of the business in a proper manner, in a legal manner, but also if any case arises or if any dispute arises, how to solve that disputes. All that will be dealt under this particular business law. Now, next it says business law establishes a set of rules and prescribes the conduct that enables us to avoid the misunderstandings and inquiry in our business relationship. Secondly, business law establishes a set of rules and prescribes a set of rules, and it will prescribe and it will tell you how to conduct the business, and that will enable us so that we can avoid maximum to maximum or max to max the misunderstandings which occurs in the business, and also the injury in a business relationship, and also we can see that there is no harm in our business relationship with the people. Now students, coming to the scope of business law. The scope of business law is indeed very vast. It is a very wider concept, right? It usually deals with the topics of license. Please listen carefully. It deals with the topics of license, large houses, monopolies, issues of securities, contracts, property, agency, negotiable instruments, foreign exchange, partnerships, companies, insurance, sales, bailment, guarantees, labor, suretyship, bankruptcy, customer interest, business crimes, rising loans from financial institutions, obtaining electricity, iron and steel, customs clearance, allotment of materials, import of capital goods, pollution control, and the rest. So these and the other aspects are being covered by the legislations and enacted by the central, state or the local bodies. So these are the various aspects which have been dealt under the scope of business law. Now students, what do you mean by mercantile law? What is mercantile law? See, a law is a system of rights and obligations. What is a law? A law is a system where it has some rights and it has some duties or the obligations, we say, obligations which the state may impose. Right? Who is going to impose? That is, the state means the government, which is going to impose as well as enforce. Impose and enforce. The mercantile law is related to the commercial activities. Now, this mercantile law is related to what? It has been related to the commercial activities. Which are the commercial activities? The trade and commerce. So, commercial activities includes trades and commerce of the people of the country. So, mercantile law means it is a law where it is a system of rights and obligations which the state might impose and enforce that particular law on the people. So, the mercantile law is related to the commercial activities, that is the trade and commerce of the people of the country. Now students, coming to the next topic, that is related to agreement. What is an agreement? See, agreement is defined by section 2E as every promise. Listen carefully. Agreement is defined as every promise or every set of promises forming the consideration for each other. So an agreement is what? It is every promise or every set of promises which is been formed by the consideration for each other. Forming the consideration for each other. Now therefore it says every contract is an agreement. Every contract is an agreement. Listen carefully. Again I am saying every contract is an agreement, but not vice versa. That means every contract is an agreement, but not every agreement is a contract. Understood? So this is about the meaning of agreement, that is the definition of agreement. So agreement is defined as every promise or every set of promises forming the consideration for each other. What is consideration? Something to get. When you give something, you should get something in return. That is what is consideration. Now coming to the promise. What is promise? Promise is defined by section 2B as what? As a proposal. Promise is what? It is a proposal or it is a offer. When accepted, becomes a promise. So when this particular proposal or the offer is been accepted by the another party, then it becomes a promise. Hence, it could be concluded that we can conclude this as an agreement is an accepted proposal. So what is an agreement? An agreement is an accepted proposal. So here students, we can see the formula. Agreement means proposal plus acceptance. So first you propose, then the other party should accept your proposal. So when you make offer, the other party on the other side should accept your proposal. So that is known as an agreement. So agreement means proposal plus acceptance. Now students, here under agreement there are two types. One is the social agreement, second is legal agreement. Social agreement and legal agreement. Now what is a social agreement? Social agreements are social in nature. They are social in nature and they are not enforceable by law or at law. Hence, cannot be called as a contract. So, social agreements are social in nature. Like as we are very social with each other, right? So, in the same way it says social agreements are social in nature, right? And are not enforceable at law. Now, for example, you may give your bike or you may give a mobile to your friend, right? So, when you give your friend your mobile or the bike to use it, do you think there is any legal agreement made between yourself, between you both? No. So, in the same way, social agreements are social in nature and they are not enforceable at law. Hence, it cannot be called as a contract. So, social agreement cannot be called as a contract. Example, here you can see, father promises to pay his son rupees 1000 if he gets first position in the examination. So, father, he will promise his son that if he gets first position in the examination, he is going to pay him what? 1000 rupees. Now, the son cannot recover the amount if the father refuses to pay the amount. So here they did not make any kind of agreement, right? It was just a social conversation. So here the son cannot go to the court of law and say that my father is ignoring me to pay me the amount which he had promised, because you are not legally binded. So this is about the social agreements. What about legal agreements? These agreements are enforceable at law. Legal agreements are enforceable at law because you are making your agreements legally. Legal agreements are composed of, what it is composed of? An agreement. Second, an intention to create legal obligation. First, an agreement and an intention to create a legal obligation. When you make an agreement, then you make an intention that you should create that particular agreement illegally. Then the ordinary test of legal obligation is that when both the parties know that they would be attended by legal consequence if they are default. So here it is understood that when you enter into legal agreement, then anything happens, if you are going out of that agreement or contract which you have made legally, then you both are bounded for any kind of consequences. You will be dealt under legal consequences if you are going away from the contract. So students, this is about the social agreement and legal agreement. So here it says intention to create legal relations. So this legal agreement, it has some intention. It has intention to create legal relationships or legal relations. So they are the agreements which do not result into contract, since the defaulter would not attended by legal consequences. So these are the agreements, it says, which do not result into any kind of contract, since the defaulter would not attended by legal consequences. The next topic is about the meaning of contract. Meaning of contract. What is a contract? See, the definition given by Section 2H of Indian Contract Act. Section 2H of Indian Contract Act of 1872. Section 2H of the Indian Contract Act of 1872, it says an agreement enforceable law is a contract. Very important. An agreement which has been enforceable by law is a contract. An agreement without enforceable of law cannot be a contract. It should be enforced by law. In other words, we can say that an agreement which can be enforced in the court of law is known as a contract. So, an agreement which can be enforced in the court of law, that means which you can go and sue the other person in the court of law, that agreement is known as a contract. A contract must have the following two elements. If it has to be a contract, then it should have two elements. First one is there should be an agreement. Secondly, it should be enforceability by law. So these are the two important aspects for making an agreement into a contract. Students, here you can see Sir William Anderson. This person also has given a definition for a contract. So he defines contract as what? He defines contract as a legal binding agreement. A legal binding agreement. That means the agreement which is bound by law between two or more persons. So for an agreement, there should be two or more persons, right? By which rights are acquired by one or more. So whatever the rights are there, that is been acquired by one person or the other person, one or more persons, to act or forbearances, that is abstaining from doing something on the part of others. So this is about the definition given by Sir William Anderson. Now there is another person named as Pollock. He defines contract as every agreement and a promise which is enforceable at law is a contract. Very easy to remember, right? It says every agreement and a promise enforceable at law is a contract. So easy it is. So easily you can remember. Even if I ask you at midnight at 12 o'clock, what is a contract? You can say, sir, contract is nothing but it is every agreement and a promise which is enforceable by law. That is a contract. So agreement plus enforceability by law equals contract. So this is the formula. Agreement plus enforceability by law will become a contract. So students, I think you understood the concept of the meaning of contract. So I hope you have understood all the topics which I covered to you, and that is the topics which I covered to you in today's first session for the first unit called as contract. Still there are more topics to cover under this particular unit 1. So we shall see it in the next class. So till then, take care. Have a nice day. Thank you.